Good afternoon, everybody. I'm Josie Osborne, BC's Minister of Health, and I'm very grateful to be here on the territory of the Lekwungen-speaking peoples, the Esquimalt and Songhees Nations. We are joined today by some very special guests. Our Premier, David Eby, Hardeep Thind with the BC Schizophrenia Society, Tess Kroeker, a psychiatric nurse, and Dr. Daniel Vigo, who is BC's Chief Scientific Advisor for Psychiatry, Toxic Drug, and Concurrent Disorders. We also have some wonderful people who are joining us in the room today. Welcome from Pathways Serious Mental Illness Society. Before I pass it over to the Premier to really get us going, I just want to say a few words about the fact that we know there are some situations where a person is in crisis due to mental health or substance use, and some of these people are a serious risk to themselves or others and are not in a position to make decisions about their own care. And we're seeing this play out across communities all too often. It is for these people for whom involuntary care may be necessary to ensure that they can get the treatment that they need when they are the most vulnerable. And ultimately, our goal here in British Columbia is to ensure that people are getting the help that they need when and where they need it. And with that, I'll turn it over to the Premier.
Thanks, Josie. It's good to see everybody here. Nice to see the folks from Pathways. Thanks for joining us. For a variety of reasons, we need involuntary care and treatment in the province of British Columbia. I think front of mind, a lot of people think of, if they're not directly personally affected by mental health in their family that requires this level of care, people think of the folks they see struggling out in the streets, downtown cores, people with serious brain injuries often, mental health issues, and addictions all occurring at the same time, leading them to be in contact with police, with the justice system, in and out of prisons and emergency rooms. And this is a cohort of patients and an evolving number of people that Dr. Vigo is particularly assisting us with right now. But involuntary care in the province also includes people struggling with eating disorders, who are very, very ill. It involves people struggling with diseases like schizophrenia that need support. And so for a significant number of people in the province, this care is necessary to save lives, to prevent worse outcomes, serious long-term injury, or other challenges like involvement in the criminal justice system, and so on. This care is delivered by incredibly hardworking doctors and nurses and health professionals in a variety of settings. We have a couple of thousand spaces in the province where involuntary care is delivered. We are modernizing or adding about 400 additional spaces at hospitals across the province. We have opened a site in Maple Ridge and in Surrey pretrial. We've identified an additional site in Surrey, and we're working on the Prince George area, and eventually in every region of the province to deliver care for people who are struggling in different ways with different mental health conditions. But the care at all these sites is delivered by frontline health workers, social workers, physicians, and others. And when that care is delivered, those frontline workers are protected by a section of the Mental Health Act, Section 31, Sub 1. That was a very old section of the Mental Health Act. It has created a lot of conversation, anxiety, that we think has been misplaced, because the function of this section is to ensure that when this care is delivered, that the healthcare professionals who deliver it are legally protected, that they know that they have our support, we understand this is a challenging piece of work, and that they cannot be sued for delivering this care. It is important, we believe, to ensure that this section is worded in a way that it is clear about what it does, that it relieves the anxiety of patients and families and advocates and others, that this is not a section that does anything other then provide those frontline healthcare workers with the legal support that they are required to do their job and know that they are supported by government and the public. So I am here to announce that we will be introducing amendments today in the legislature to Section 31, Sub 1 of the Mental Health Act to make that language very clear, to replace the dated language of the existing section with very clear language that exists in other health laws in the province that just says that these healthcare workers are protected when they're delivering this involuntary care in our province. Now, we are in court right now defending the involuntary care provisions of the Mental Health Act. We think it's important that these provisions exist. We think it saves lives. We think it protects dignity. We think it gives people an opportunity to rebuild their lives after facing catastrophic mental health challenges. It is important that this exists. And so we're in court making those arguments right now. This change that we are introducing in the legislature does not make that court challenge irrelevant. It doesn't have an impact on whether or not the court is able to grapple with this important question about what the limits are on involuntary care or treatment. It just provides healthcare workers with the certainty that regardless of the outcome of this legal case, they will be protected in delivering this care, because we think they need that certainty going forward. Section 31, Sub 1 has been specifically identified as one of the sections that is being challenged in the litigation, and we need to be very clear that regardless of the outcome of the case, that the healthcare workers will be protected in the work that they do. That is crucial. So the outcome of this provision passing, we hope it has three main effects. First of all, that it protects the healthcare workers that I've been telling you about, that they know with certainty they're protected in the work they do. The second is that patients and families know that this care is being delivered for the right reasons, through the mechanisms that are set out in the Act, and not for any other reason. And the third is, we think it strengthens the purpose and the clarity of the Act that is crucially important for healthcare in the province of British Columbia. So for those three reasons, we have decided to introduce this amendment this afternoon. I want to thank all the people who are here speaking today in support of this work, and thank them for the work that they do outside of this place on this important issue. Delivering voluntary care in community is crucially important for our government. Mental health and addiction services like the Foundry, like drug treatment across the province that we've dramatically expanded. But sometimes it's necessary to ensure that we have services where we can deliver involuntary care in this province. It is unfortunate, but it is a necessary reality. And if we're going to do it, we're going to treat people with respect and dignity and do it the right way and make sure that the healthcare workers who deliver that care are looked after as well. So thanks very much for coming today. And with that, I'll pass it back to Minister, or I'll pass it over to Hardeep. Great. Who will come up and speak next. Thanks, Hardeep.
Thank you very much. It's been a real pleasure to be here this afternoon. My name is Hardeep Thind. I'm with the BC Schizophrenia Society. I have been with the organization for 24 years. And what we do is we support families. We support families who have serious, persistent mental illness in their family and ultimately their loved ones who have diagnosed or undiagnosed illness. And this announcement is incredible for the families. We're very grateful. Legislation can be only as good as people understand how to implement it. So having the ability to understand how they can help and support families, it's really important for families to know that they're the caretakers. They're usually the ones at home watching the behavior unfold, what's happening for them when their loved ones, and they're at their wits' end and they don't know what to do. They may have tried calling the police, trying to get involuntary admission on that end. And if they do manage to get their loved one to hospital, only to admit that maybe they aren't going to be treated because they're not ill enough, it's really important for them to be able to have involuntary admission along with involuntary treatment. It really is important to understand that, and we really strongly believe in that, and we advocate that for our families. We in turn empower them. And I also come to you as a family member. I've been a family member for 34 years, supporting my little baby brother, who's my 6'7" cousin. And he is in an incredible place today, thanks to the involuntary treatment that our family had to very harshly take upon that time in order to get him service and treatment. And that was 34 years ago, and he's thriving. He's doing incredible work in the community. He's contributing. He's grateful. He's exceptionally grateful that we took that stand at that point in time against all wishes and had a review panel and wanted to get out because he didn't believe he was sick. But with the ability to have that involuntary treatment and keep him there as long as he needed to be there to get well. These are stories that we get from families every day. They're very honored and blessed to know that this treatment's in place for them. No one takes getting someone into treatment lightly. We very truly think twice about having to call the police or having to have intervention of some kind that is ultimately incredibly drastic and really disheartening for families, and it really makes a huge emotional toll on them as well. So I thank you for this opportunity. It's grateful, very grateful to be here.
Good afternoon, everyone. Minister Eby, honored guests, members of Parliament. It's a pleasure to speak to you today. My name is Tess Kroeker. I'm the Director of Nursing at Douglas College. I'm the chair of the Nursing Educators Council of British Columbia and a proud nurse for almost 30 years. It's a great honor to stand before you today to speak both as a healthcare professional and a member of this community. I wish to extend my warm regards to the Premier and all members of the Legislature for your steadfast commitment to improving mental health service for the province. The Mental Health Act remains a guiding framework for how we care for individuals living with serious mental disorders. It not only enables access to crucial treatment, but also enshrines the essential legal protections that safeguard dignity and the human rights of every individual under its care. The Mental Health Act makes clear that the patient's rights must be protected and that every healthcare agency in British Columbia carries the responsibility to uphold these guidelines. We must ensure that all implementations of the Act occur in a manner that is respectful, informed, and inclusive for all patients. Equally important is the Act's protection of caregivers. Those who work in direct care often face complex and high-stakes situations. The Mental Health Act affirms their work is supported and shielded by legislation allowing them to provide care without fear and with the confidence that the law stands with them. The legislation must be robust and adaptable enough to support care across the entire spectrum. From unfortunate to extreme circumstances where risk is a matter of life and death, to more routine but equally vital moments in care. It gives practitioners both the guidance and the assurance needed to make difficult decisions while always centering patient well-being and their community. By working together, patients, families, healthcare agencies, lawmakers, we affirm our shared commitment that every individual is treated with respect and equity, that the patient rights are always the first priority, and that those tasked with care are never alone in their responsibilities. Let us continue to build a system that is compassionate as it is strong. Thank you for your trust and for your leadership and the opportunity to be part of this important conversation. Thank you.
I'm grateful to be a visitor on the territories of the Lekwungen peoples, the Songhees, and Eskimo nations today. Thank you, Premier Eby, Minister Osborne, for your support for my work. Thank you for the guests here. And special thanks to Brenda Doherty, Rachel Staples, and the many other parents who, despite their unimaginable loss, continue to work so that what happened to Stephanie and Elliot never happens again. Brenda Doherty was going to be with us today, but her grandson was born yesterday, and so she couldn't join us, but she is with us in many ways. In September of last year, I presented recommendations for improving the care of people with severe mental disorders, substance use disorders, and acquired brain injury, including the creation of beds across the continuum of care, as the Premier just mentioned, of which around 200 are either available or underway, including approved homes in Maple Ridge, the mental health unit in Surrey pre-trial, and the ones that the Premier mentioned, the tertiary beds to cover the BC North and the Lower Mainland. I have also been working with municipalities and the remaining regions to identify new sites, which I will be visiting shortly. Today we focus on a cornerstone of the care for people with severe mental illness, which is the adequate and consistent use of the Mental Health Act. As the Premier indicated, we are moving on several fronts, strengthening the Act that we have, developing a robust process for its long-term improvement, and, most urgently, clarifying how it should be used consistently across the province to its full therapeutic extent. And make no mistake, the Act is a powerful tool when used properly. It saves lives and prevents brain injury. It opens the door for the long-term treatment and recovery of our patients of all ages, because that is where our focus is, where it should have always been. During the past 10 years, there were 250,000 overdoses in our province, which happened to 100,000 people, killing 17,000 British Columbians. Of these overdoses, more than 13,000 happened to our children and adolescents. More than 1,500 kids overdose for the first time every year. And we have shown that after they do, a quarter of them have horrific immediate outcomes. 15% chance of repeat overdoses, 7% chance of acquired brain injury, and more than 2% chance of dying, all within a year of their first overdose. We have also shown that kids who will die of an overdose have, in average, 5 years to live after a anoxic brain injury shows up in their medical record. And these are very conservative estimates. It is not just severe brain injury and death that we're up against. We have also seen that clinically undetectable brain injuries occur after any overdose, meaning that the burden of brain damage is much broader than what is captured in a patient's record. So, when we encounter a child with a mental disorder that includes exposure to synthetic drugs, there is no time to lose. We need to intervene in the moment to prevent brain damage and death. How do we intervene? We always protect the rights of the child and always use the least restrictive intervention possible. In very severe cases, however, the least restrictive intervention is admitting and treating the child, even if it is against their wishes, preventing the irreversible restriction on the exercise of liberty that result from brain injury and death. There is a lot we can do, even with the system we had. When a child with an overdose or with a post-overdose confusion shows up, we should immediately connect with the child parents or guardians to understand the background and define what the best treatment plan is. And that plan will vary. It can mean referring the child to a bed in BC Children's or Maples or to a substance use recovery bed. It can mean connecting them and the family with Foundry or the community teams that exist across the province. Importantly, it can also mean admitting the child to the ED or pediatric unit just long enough to adequately diagnose and provide life-saving medication, the protective effect of which may last for months. Such interventions will certainly not cure the child's addiction, but it will, without a doubt, provide time for the health team and the family to understand the full mental health needs of the child and develop the best possible plan, significantly reducing the risk of brain injury and death, even if it's only a few months at a time. In May of this year, I provided guidance to physician and nurse practitioners on how to deliver life-saving, brain-sparing interventions to adults with substance use disorders under Section 22 of the Mental Health Act. Soon, After receiving and integrating the feedback that we're awaiting, the province will be releasing a new document clarifying that, under specific conditions, additional avenues are available, which will allow us to provide care at the request of the parents in order to ensure that our ability to prevent brain damage and death are maximized and that treatment and recovery become a possibility.
Thank you, everyone, for joining us here today at the Press Theatre here in Victoria. I'm going to take questions from the media now. All members of the press will have one question and one follow-up. And we're going to start with Katie DeRosa from the CBC.
Premier, we're hearing news that the Prime Minister and Alberta Premier Danielle Smith could be inking a deal as soon as Thursday. Are you yet involved in those talks? And if not, why not?
Thanks. I had a conversation with the Prime Minister this morning. He's recently returned from South Africa. He has outlined to me that the agreement with Alberta is not finalized yet. And I took the opportunity of our conversation to outline British Columbia's perspective. First of all, that coastal First Nations consent and support is required for this conversation. And even if Alberta is indifferent to the legal rights of the coastal First Nations and their rights and title in the area, I'm sure they are not indifferent to the fact that coastal First Nations support for major projects like Silism's LNG Canada Phase 2, expansions to the Port of Prince Rupert, all of which involve the transport of products, including products from Alberta to Tidewater. That coastal First Nation support is required for those too. Second, that I do not believe that Alberta should have access to a $50 billion taxpayer-funded pipeline unless other provinces and territories have access to similar amounts of taxpayer funding. There is not a world in which the current price of oil, a private company is going to step up and pay for this pipeline across the north. This is the reason why not one single pipeline company has said if the conditions are right, they would build it. If it's built, that they would buy it. The reason for their silence is that they are not interested, just like they're not interested in buying the pipeline that we already have, the taxpayers own, that is for sale, if anybody's interested. My message to the Prime Minister was that either there should be a cap on the taxpayer dollars invested in this project, or there should be a prohibition on taxpayer dollars invested in this project, or if it is going to be taxpayer funded, that British Columbia get access to a $50 billion federally funded project as well. The third piece that I underlined for the Prime Minister was British Columbia's support for the oil tanker ban off the coast. The Hecate Strait is wild water. It is an incredibly precarious shipping route. It is the reason why the ban on oil tankers has existed for generations across multiple administrations of different political stripe in Canada and in British Columbia. The reason why these supports have been there for this, whether it was in law or not, formally or informally, is because of the dangerous waters in the Northwest. A heavy oil spill will decimate a $1.7 billion industry of fisheries and tourism and a way of life for people in the Northwest that have been living that way of life for millennia. I explained all of those things. I asked that the Prime Minister incorporate those pieces into the agreement. He listened carefully, made no commitments on it. But I said at a minimum, coastal First Nations and British Columbia need to be at the table in these conversations about our province. So I look forward to seeing what the Prime Minister and Premier Smith bring forward in the coming days, potentially.
Follow-up, Katie?
In regards to these changes on Section 31, the court case, as you said, was focused on the deemed consent provision. So does this change effectively, what does it do to the lawsuit, since this was really the focus of the lawsuit?
Well, involuntary care existed in the province before this section existed. This section is about immunizing the healthcare workers, protecting the healthcare workers who deliver this care from being sued. It uses archaic language around deemed consent, so we're modernizing the language to make it clear what the section does. My understanding is that the AG perhaps can clarify, is that our lawyers are communicating to the court that the exact same arguments that have been applied to this section can be applied across the entire Act, that this shouldn't frustrate the ability of the court to consider the important questions that are being advanced here. The position of British Columbia is unequivocal. We believe the Act is essential. We believe that these treatment provisions are essential in order to save lives, in order to protect people, and ensure that they get the health care that they need. Those are the arguments we've been advancing in court with the support of some of the people and some of the organizations you've heard here today, and we will continue to advance those arguments in court. But this isn't going to be a case that, that goes away on a technicality. The court will grapple with this important question, just like it has in other provinces, and I suspect it will make its way up through the various levels of court. But we want it to be absolutely clear that regardless of the court outcome, that the frontline healthcare workers that do this work in our province, who are so valued, so appreciated, that they are protected.
Rob Buffum, CTV.
Well, hi, Premier. I just wanted to understand as best as I could, or get some clarity on the reason for amending Section 31. Is it that, presumably it's, but you tell me, it's that involuntary care was not being applied as much as it was felt it should be because healthcare workers were worried they were going to be sued or get in trouble. And if with this amendment we'll see broader application of it and we'll see healthcare workers feeling more comfortable applying the existing law?
Thanks, Rob. This shouldn't change at all the decision-making process around involuntary care in the province. Those are the involuntary care is applied on the basis of a decision by the director under the Act. It's an entirely different section of the Act. What this does is it changes the language from an archaic language, an old construction that said the patient was deemed to have said yes, the patient was deemed to have consented, and therefore the healthcare workers are protected. That has obviously caused a lot of anxiety and concern among advocates in particular, saying, you know, why is the law saying that I consented to this? Or why is the law saying that patients consented to this? Because they clearly didn't consent to it. So we've updated the language to reflect other health laws in the province and said very clearly that the healthcare workers who administer this care under these other sections of the Act are protected from being sued. It doesn't talk about the patient having deemed to have consented. It just states that the law is standing behind these healthcare workers who deliver this care, and they're protected from being sued. In a perfect world, this has absolutely no impact at all on the care that's delivered because it's all delivered under a separate section. But it does provide some reassurance. These healthcare workers who may have heard that this section was being challenged in court may be concerned what happens if the court comes and says the section's invalid, that they will know that regardless of the outcome of the court decision on involuntary care, that they will be protected. It will give them, the big change will be, it will give them the comfort to know that regardless of the outcome of the court decision, that they're protected in the work that they do.
By way of follow-up, I've got a question from a colleague about application of involuntary care to young people or youth. They've worked on various stories, including one recently about one family who told them a teen had overdosed and ended up in hospital 4 times in 4 months, and this feeling that there wasn't a lot parents could do. I took it from Dr. Vigo's comments that there will be more news about involuntary care as it relates to youth, but I'm just wondering, and my colleague wants to know, basically, why do parents face such a difficult time getting help with young people dealing with drugs or mental health issues? And are changes coming?
Yes, thanks. Dr. Vigo's done some very important work for the province in his role as Chief Scientific Advisor. First, around adults, to ensure consistent application of the Mental Health Act across the province. We made a commitment when that work was completed that he would do work in relation to children or people who are infants under the law going forward. He has been doing that work, that engagement with medical professionals, various stakeholders, and so on, and is currently incorporating their feedback into the draft guidelines that he has prepared. And we hope to be able to release those as soon as possible. I'm cognizant of the fact that Ms. Doherty is marking both a celebration of the birth of a grandson today, but also the anniversary of her daughter's death on Sunday. And so this guidance can't come a moment too soon, in my opinion, but it's important to do it properly and carefully and respectfully. And so that's what we're doing, and Dr. Vigo and his team are working hard on that. And I look forward to have more to share with you soon.
Next, we'll head to Rob Shaw, Check News.
Hi, Premier. Back on the pipeline position, do you feel in any way that your position of kind of a hard no on this caused Ottawa to exclude you from these conversations? Did you get any type of apology from the Prime Minister when you talked today about being cut out of this? And is there any commitment going forward that you're going to be included in it?
You know, I'll let the Prime Minister speak for himself about this. I underlined for the Prime Minister how unacceptable it was to me to have Saskatchewan and Alberta speaking about matters in British Columbia without British Columbia at the table. This is not something that would happen to Quebec. This is not something that would happen to other provinces in the Federation. I don't know why the thought was that it would be okay for it to happen in British Columbia. But regardless, I was very clear that my expectation is that going forward, that British Columbia be at the table and that we're able to participate in these crucially important conversations. We don't have to agree, but it is absolutely crucial that the perspective, knowledge, and relationships of British Columbia are leveraged at that table to make sure that we reach the best conclusion for the people of Canada possible.
I'll double barrel this one to get as much in as I can. Do you feel at all like the announcements from Ottawa on funding and the major projects office in the last few weeks and months were in any attempt to sort of, you know, fatten you up like a plump Christmas goose before Ottawa comes in and drops this pipeline on you? Does it seem genuine looking back that BC got half the major projects when you're about to get whacked with a pipeline? And then also, did the Prime Minister explain what's in the MOU, and can you comment at all about these reports that it would carve out an emissions cap, carve out the tanker exemption, carve out the clean energy regulations, create some sort of tier system on carbon credits, and require the Pathways project from Alberta, which seems to be the broad direction that we're going here?
I'll let the Prime Minister speak about the agreement. The one piece that he underlined for me was that the agreement was not finalized at this point, and my expectation and hope is that BC's feedback is incorporated into any final agreement, and particularly BC's participation going forward and respect for the role of coastal First Nations. Look, I think from the perspective of British Columbia, when I have the opportunity to meet with other premiers and I hear what they're working on, I will say with respect that the vast majority of major project opportunities in this country right now that are close to final investment decision are in British Columbia. It's an incontrovertible fact. It is, regardless of the small p politics, there is no other province that has tens of billions of dollars of major projects at final investment decision with private proponents, permits in place, ready to go. So it is not and has not been a surprise to me that British Columbia has 4 times more major projects on the board than any other province in Canada. What has been a surprise, and an unpleasant surprise to me, is the willingness with which Alberta and the federal government are willing to potentially jeopardize those projects by disrespecting the coastal First Nations and their very serious and legitimate concerns about eliminating the oil tanker ban off of the Northwest Coast. Because their support for these other projects is essential for them to be able to move forward. I have underlined on a number of occasions to the federal government and publicly my sincere desire that Ottawa not play politics with major projects. If there are major projects with private proponents that are close to ready to go that will assist us as a country to stand on our own 2 feet, those projects should be prioritized. We have equalization already in this country, where other provinces are supported by British Columbia. Take it or leave it, that's the way it is. So from my perspective, Ottawa should be taking a perspective of what can we deliver, how quickly can we deliver it, and with all due respect to the pipeline project, there is no route, there is no proponent, there is no company, there is no money. And when you compare our proposals to Alberta, they could not be more different.
Next, we'll head to Wolfgang Detmer from the Canadian Press.
Yeah, hi, good afternoon. Thank you for taking my question. Premier, earlier you described as the agreement, as this MOU between Alberta and Ottawa not yet signed. How much are we to read into the fact then that you have all but accepted that this agreement is coming down the pipe? And how resigned are you to the fact that this is coming forward? And I haven't heard anything yet. Haven't heard anything yet about any potential measures you might take to challenge this agreement. Thank you.
Thanks, Wolf. Well, I mean, there's a couple of components to this. First of all, I'm not threatened by a project that doesn't actually exist. The entire proposal from Premier Smith is a communications exercise. There is no company, there's no money, there's no route, there's no nothing. And so, you know, I try to keep that front of mind as I wrestle with the fact that the entire country seems to be particularly interested in this non-existent project when British Columbia is delivering tens of billions of dollars in real projects, thousands and thousands of jobs, billions of dollars of revenue that will flow to federal and provincial coffers if we can close these deals which are approaching final investment decision in the next 12 months. And so trying to keep perspective about these things is pretty crucial. I understand the need for the Prime Minister to engage with premiers across the country. I'll reserve my judgment about the content of the agreement until I see it. But as far as that agreement touches British Columbia and our interests and our province, then British Columbia needs to be at the table for that conversation. I don't think that's unreasonable to ask. I'll look forward to seeing the agreement when it's completed, and we'll move forward at that point.
I'd be curious to know what the Prime Minister's reaction was when he told him how unacceptable it was for BC to be cut out. But I want to move on to a different subject, and that's the question of DULF. What, if any, legal advice did your government seek or receive prior to handing money to that organization? Thank you.
Yeah, I understand that Vancouver Coastal Health was funding that organization. When we learned that this organization was engaged in drug trafficking, that we directed Vancouver Coastal Health to immediately terminate the funding. The individuals involved were arrested. We supported that. They were prosecuted and convicted. Our expectation for every service provider to the province of British Columbia is that they follow the law, full stop, no exceptions.
Next, we'll head to Mark Page from the Black Press.
Yeah, this might be a question best for the Attorney General. Just on the involuntary care, court challenge. From what I understand, that the closing arguments were just heard in that case. I think they were just heard, or they were scheduled for the end of October, beginning of November. Maybe we could just get an update on that, and then also just was there anything that was heard in those closing arguments that made this move necessary, that made there be more of a worry that healthcare workers were going to be somehow liable for the care that's given involuntarily?
Yeah, thanks for the question. The arguments for this case were formulated and delivered well before these amendments. So we have a team of lawyers that are right now defending, as the Premier mentioned, our position and our legislation with respect to involuntary care. The Premier articulated the reasons for the changes in terms of the liability protections that are more clear with these changes introduced with respect to health professionals. The judge will hear the last day of closing arguments and make their decision related to what our team has put before them. That's the context of the legal case.
A follow-up, Mark?
Yeah, just on that last question, wanted just some clarity on when that would be, like the end of those closing arguments. And then on the Cowichan Tribes case, this is probably also a question for the Attorney General. I'm just wondering if the application for a stay has been applied for, if it has been filed, sorry, and if it was filed, when was it filed, and if it hasn't been filed yet, when will it be filed?
Yeah, thanks, Mark. Final arguments in the Mental Health Act challenge completed last week. Our counsel have been clear with the court and with the other side that this amendment will likely require the reopening of argument so that the court is able to consider it and so that both sides are able to put their best positions forward. It will assist and support the court in deliberating on the core issue, which is involuntary care in the province, and we're hopeful that it'll be able to provide a more useful decision for us as a province and for the applicants as well. On the Cowichan decision, I will pass it to the Attorney General in a second, but I will say that it is absolutely crucial that the province prepares a stay application that is comprehensive and that will be successful. Part of that work that we've been doing to prepare for the stay application is we have had a staff member from the Premier's office meeting with residents in Cowichan who are affected by the decision to gather information about any impacts that have been taking place on the ground. We can't just take information from Twitter or from opinion pieces. We have to actually learn from the people who are affected by the decision what's going on the ground. That information will be incorporated into the stay application, which will be filed in front of the court. We're also hopeful to be able to work with other parties going forward on the stay application. I know that both Musqueam and Tsawwassen have been approached in terms of their willingness to participate in a stay application as well. All of this is an aim to ensure that we're able to be very clear in our efforts to protect private property while respecting the need for ongoing reconciliation and partnership with First Nations and recognition of historic title and wrongs that have been done to First Nations in this province. It's a delicate balance, I'll acknowledge, but it's a crucial one for the future of our province, whether it's economic development in our major projects, which are being done in partnership with First Nations, or whether it's the reality of the fact that that land was illegally taken from First Nations, very specifically in recent memory in our province, large groups of people displaced from a particular piece of land, including this land here in Richmond. How do we find a path forward on this? So with that, I'll pass it over to the Attorney General on the details on the stay filing.
Yeah, thanks. The Premier really summarized the goals. So we have somebody on the ground speaking directly with potentially impacted landowners. All of that is really important for our ability to collect and understand the impact so we can put that before the court in the stay application. Our team's hard at work, and I suspect it won't be much longer before we're ready to file the stay application. I'm happy to obviously let you all know when we're ready to do that.
Thank you. Next, we'll head to Fran Yanner from the Northern Beat.
Thank you. Thanks for taking my question. I guess I'll just to follow up on Wolf's question on Dolph. Again, respectfully, Premier, again, you've said that your government stopped funding Dolph as soon as you learned of the drug trafficking. But your Attorney General, when she was your parliamentary assistant and you were Attorney General, in June 2022, learned directly about the drug trafficking operation that Dolph was conducting and did nothing. And then subsequently your government funded them. So I don't understand how you can square that circle.
Well, Fran, as soon as I learned that Dolph was engaging in illegal conduct, we directed Vancouver Coastal Health, which was the entity that was funding that organization, to immediately terminate the funding. My expectation of every government entity and agency, and this includes Vancouver Coastal Health, is that if they learn that an organization is breaking the law, that funding needs to be terminated immediately. It is a basic expectation that I have and that all British Columbians have.
A follow-up, Fran?
Yeah, thanks. Well, Dolph's very first illegal drug giveaway was June 2020, and it was advertised. It ran on the BC Centre for Substance Use website. And your Attorney General, your now Attorney General, learned of it a year and a half before you cut funding. So sounds like you're saying, even though she was your parliamentary assistant, you never learned the information that she had, that Dolph was illegally drug trafficking. But your Attorney General was aware of that long before your government cut funding. Is that acceptable?
And as soon as we learned that DOLF was involved in illegal activity and receiving government funding, we directed Vancouver Coastal Health to cut off the funding to this organization. It's a basic expectation that I have, and that all British Columbians have. It is a reasonable expectation. It is a baseline for our province, and we will ensure that that continues to be the case in the province.
Thank you. Next, we'll head to Andrew McLeod from the Tyee.
Yeah, hi, Premier. Last week, George Anderson's bill on professional reliance got second reading. UBCM and others have been raising concerns about it. Is it the government's intention to pass that bill? Why or why not?
Yeah, thanks, Andrew. We have a new system here in the legislature of private members' bills actually having the opportunity to be called and be voted on in the legislature. It's a great opportunity for members of all parties to be able to advance legislation, and we have seen laws advanced by the opposition that actually get passed in the House. So I think it's good for democracy as well. George Anderson has brought forward an amendment or a law that he would like to see brought into place in the province. It's passed first reading and second reading. The third stage is committee stage. And during committee stage, members of the public service as well as key stakeholders will be heard from about their perspective about whether or not this bill is a good idea. And I think it'll be very helpful for all members of the House to hear that committee stage debate, and we'll decide accordingly how to vote after that based on the committee stage debate. So it's a different kind of process than a government bill. But I think it is net positive for democracy that members, including backbench members, are able to bring forward laws and proposals about how to improve our province.
Do you have a follow-up, Andrew?
Yeah, I would just observe that any bill, even if it's a private member's bill, still will need the government's support to pass, just because you have a majority. But on a different topic, there's a group from the BC Association of the Deaf who've been seeking a meeting with you. They're concerned that the government backtracked on plans to redo how language acquisition is done for deaf and hard of hearing children. Will you be meeting with them? Why or why not?
I'd certainly be glad to meet with them, Andrew, but I'm not familiar with the issue at all. I'll look forward to hearing from them about their concerns at that meeting.
We have time for one more question, and we're going to head to Mr. Vaughn Palmer from the Vancouver Sun.
Premier, with the arguments concluded in the case, you're amending a section of the law deemed consent. There was an issue back in the spring. The people opposing this have been complaining about that for months, if not years. Don't you think it's bizarre when the case is over, you're finally getting around to changing a section of the law? Like, didn't you know this was a problem before this thing went to court? And why didn't you change it back then?
Thanks, Vaughn. Absolutely. Look, we know that the Mental Health Act is a law that has been around for a long time. It has some archaic language in it, and we've committed to do a review of the entire Mental Health Act and be able to modernize that language, ensure it's able to achieve our goals as a province. The specific section that was challenged by the applicants in this case is the section that provides protection for frontline healthcare workers. As we get closer to decision date, there is some reasonable anxiety among the frontline health workers that if this case is successful in overturning that provision, that they won't be protected. I'll certainly acknowledge that this section's language has been a challenge for a long time for advocates, for others. They have been concerned about it. Our desire has always been to address the Mental Health Act and as part of a comprehensive review. It's a massive piece of work. And in the meantime, we have this court decision. It's come up much faster than the Mental Health Act review. We need to provide the protection for the frontline healthcare workers and the reassurance so that they're able to provide this care uninterrupted regardless of the decision of the court. And I agree it's not ideal, but it's necessary, and it's better that we provide that care and reassurance for our frontline healthcare workers and defend the act than leave it out and uncertain for them, given the importance of the work that they do every day for British Columbians.
Thank you. You mentioned last week when talking about Scott Moe's presence in the pipeline talks, I think the day you spoke, big Saskatchewan-based potash company had announced that it had looked at ports in British Columbia and elsewhere and decided to go with Longview, Washington. And you asked why Scott Moe hadn't been out here in British Columbia talking to you about that. Is it correct what I gathered from what you said, that BC and Saskatchewan have not been working on the challenge of this huge expansion of ability to ship potash through BC ports, and making sure it didn't go to Washington State, that it just happened?
Thanks, Vaughn. Yeah, I was really disappointed to read of the decision of Nutrien, which is a huge potash mining company in Saskatchewan, to be shipping their product out of Washington State. And the reason why I was disappointed was twofold. One is obviously there's the potential for port expansion in British Columbia, which I'm a big fan and supporter of. I think that we are ideally suited to ship bulk materials like potash to world markets, but also for the people of Saskatchewan. You know, this means if you live in Saskatchewan, that your resource is in the hands of Donald Trump. He may decide to put a tariff on Saskatchewan potash that passes out of the state of Washington. He may decide to close the border to Saskatchewan potash if he decides that, that Canada has done something that offends him. And so it puts Saskatchewan's resources in a precarious place, and it denies British Columbia a chance for port expansion. That seems like the worst of both worlds. And so I was quite surprised to see that announcement, because I've interacted with Scott Moe many times. I have said to him that it's exciting that more potash is going to go out of BC ports, West Coast ports. He never once raised that there was any challenge with Nutrien, that they needed any support. I engaged with the Prime Minister and senior members of Cabinet on multiple occasions about the opportunities around port expansion in British Columbia, how excited we are. We put port expansion on our major project list multiple times, and we're here. You know, we're ready to go. And I really encourage all the premiers in Canada who are shipping through British Columbia to engage with me on this important issue. And I guess the piece that really bothered me the most was that instead of talking with British Columbia about potash shipments, the Premier of Saskatchewan was allegedly talking with the federal government about Alberta's fictional oil pipeline project. And that really was just the cherry on top.
Thank you very much, everyone. That concludes today's event.